want to focus my remarks on how we create a family court system that has justice at the centerpiece. It's been said that the history of justice is the history of procedural protections. And something that I'm an expert in, since I've been here for 50 years, been all through courts, is process is essential. And so let me enumerate what I believe are critical components of a reform package, and then how we can try to implement this particular program. And remind everyone, as an example, things don't happen overnight because the status quo has defenders. In 1848 at Seneca Falls, the organization was formed to obtain the franchise for women. It's 1919, success came. So it doesn't always take that long, but you need to be in for the long haul, because those who currently occupy the current positions will move heaven and earth to retain it because they benefit from it. This is just a reality we have to recognize. I believe perhaps the simplest and one of the most important reforms is transparency. The U.S. Supreme Court has held that you have a constitutional right to attend criminal trials, mostly civil trials. And this is something that simply doesn't happen in the typical family court system. Justice Brandeis once said that sunshine is the best disinfectant, the electric lamp the most efficient policeman. So keeping things secret encourages, emboldens abuses just by itself. I believe Bandy told me that there's been some innovations in Great Britain where they've opened up the family court proceedings, and the amount of complaints is diminished by 50% overnight. So how do we do this? At least at present, you know, the U.S. Supreme Court has not held that there's a First Amendment right at the family court level as opposed to criminal trials to attend. But I believe this is a case of legislative reform. There's no reason why state legislatures can't demand that family court matters be held open. There's just one exception I would suggest. If there's fact-finding that publicity would cause direct, immediate, and irreparable physical or mental harm, you could close the proceeding just for that purpose. But that is essential, that there be openness and transparency. It encourages responsible behavior, it deters wrongdoing. Now, a second element here, I believe, there was an expert, Henry Wigmore, he said cross-examination is the greatest engine ever discovered to obtain truth, cross-examination. And I believe, again, that there should be no participant in a family court hearing that can escape cross-examination. Again, absent a factual finding that the cross-examination would create imminent danger of irreparable direct harm to physical and mental safety and comfort. Those, in my judgment, would probably cure a very large percentage of all the injustices that you can chronicle here at this meeting. I don't think that chronicling them, it provides therapy for everyone. I don't want to be callous, but it doesn't move the ball forward, because we all know that this is not anything novel. The kind of tragedies you saw on the film that you can recount today, they're over and over and over again. It's not something new on the block like AI, and there's something that's structurally wrong in the family court system. One of the things that might be considered in family court is a right to trial by jury, or at least an advisory jury. So you just don't have one person there. If you have a jury, cross-section, I think you'll get people who are engaged. They'll be more sympathetic and understanding. They won't have nearly the arbitrariness of the single judges that you find at present. And moreover, there's a deliberative element. You have different persons from different backgrounds. You could even have at least an advisory jury as opposed to binding jury. That happens in criminal justice regularly, where a jury will recommend a sentence to a judge, but it's not binding. And I'm suggesting that these as ideas. I'm always reminded that we never want to propose a cure that's worse than the disease. And whenever you have an innovation, we're not brilliant enough to foresee every contingency, and we need to be careful that we don't make things worse, even though our intent is pure. There's also, I believe, we should have a system of a right to counsel. If a parent, a party, doesn't have sufficient funds in the criminal justice system, generally you have a right to counsel paid by the government. There ought to be a right to counsel in family court as well, including, I believe, counsel. I've argued a constitutional right of a child to have independent counsel. The best interest of the child is the typical standard, and the child doesn't even have a right to independent counsel. It seems a little bit odd. You can't suggest that someone else can stand in the child's shoes. The parents have their own ulterior motives agenda that may be similar to the child's, but it's not the same. This is something that I believe we can clearly afford and is essential. Right now, oftentimes, if you don't have money, your opponent can hire talented and gifted attorneys. If you don't have an attorney, there are issues, technical issues of evidence and motions. It's going to escape you. It becomes a very unjust system. And here, I think, we can try to compare, the importance of the issues at stake in family law, when we're speaking of child custody and very, very intense family relationships with the criminal justice system. So criminal justice kind of has the highest tier of procedural protections. But I think if you take away the dollar figure, perhaps family court involves more intense psychological stress, anxiety, impact on a person's life, other than criminal justice. Maybe in some cases more. Your entire life could be destroyed with injustice at the family court level. And therefore, if the criminal justice system can provide these protections, the same ought to obtain in the family court system. In some sense, it's equally, if not more important, because you can imagine in your own experience that because of the personal investment involved, and oftentimes the rancor, the reason why you're in family court is because something is dysfunctional in the family situation. Otherwise, you wouldn't be in court. And so we need to remember that for that reason, the need for care and scrutiny of what's being said is at its zenith. And that means, I say, the right to cross-examination, including children from time to time. But when we're undertaking these innovations, oftentimes out of caution, we have pilot programs. We don't say we've jumped, we've discovered the law of gravity at the first mathematical equation like Isaac Newton. It took a long time. And so we need to make certain that we reevaluate, these innovations. Are they working? Are they not? So we don't end up, again, going down a wrong path. You can do that with sunset laws. After 3 or 4 years, you come back and revise the system to see whether the transparency, is the cross-examination working, is the jury trial working, something of that sort. And you could even start, I believe, pilot projects start out in one state, which could serve as a model for other states. There is a group called the Commission on Uniform State Laws. When I was in law school, we learned about the Uniform Commercial Code. It's not binding on all states, but you can find Uniform Family Code as being a model for legislators to embrace and adopt. But I want to suggest also, other elements that come into play, I think are important with regard to how do we select, family court judges. It's very important, in part because, and I don't want to speak in any way that's condescending, family court judges are not usually the people who graduate from Harvard and Yale top class and sit on the U.S. Supreme Court, because it doesn't carry that prestige. I've been in family court before, and I'm not overly impressed with the intellectual brilliance of the judges. So that means that we need to be careful about perhaps a new way to recruit and appoint family court judges. One way to consider it, typically you appoint judges or you elect judges. And sometimes you appoint judges and they're up for retention election. And then it differ about, do they serve 6 years or 8 years or whatever? Should there be a retirement so you get new blood in the system? I believe all these things need to be re-examined because at present, it's, again, it seems to me, you may know more because you have more experience sitting in there. There's kind of an incestuous relationships among all those who are working in the family court system. They all scratch each other's back, they know each other. There needs to be some outside scrutiny that will cause them. That's one of the reasons why transparency is so important here. But again, I'm just suggesting ideas that would be considered in writing, you know, a new family code, if you will. Now, one of the other things to think about in regards to having a higher quality of judge in the in addressing family court matters is maybe we should have the family issues put on the agenda of the regular circuit or trial courts. Why do we have just special family court? Which means they come with a very narrow mind. In regular civil justice system, in the federal system, one judge handles all sorts of cases, you know, ranging from breach of contract to antitrust to securities laws to gender discrimination. And if you have a generalized experience and background, you may bring more enlightenment to a situation without prejudice than you do if you just have one kind of case. It's rather unusual in our system of justice that the jurisdiction of a court is so limited to just one item. We have tax courts, but those are the exceptions rather than the rule, and I do believe you would probably attract a better quality of judge if the jurisdiction was broader and family law issues were just part of a larger agenda. But again, we don't know for certain. That's why we need to make clear that at the outset we want pilot programs, sunset laws. We need to come back and reevaluate exactly how these situations are working. Now, one of the other elements I believe is disadvantageous to justice is the fact of absolute immunity of the participants. You can't sue them for anything, even if they act out of malice. That seems to me much too broad. I believe that for most government officials, they enjoy a good faith immunity from being sued, and I can guarantee you they don't get sued all the time. Lawsuits are a headache, especially for plaintiffs. This idea that if you reduce immunity, suddenly there'll be 1 million lawsuits brought is nonsense. Any lawyer who practices knows there are numerous inhibitions on filing a lawsuit. Your entire life is wound up, it's expensive. Who wants that headache? You gotta sit for depositions. And I do believe the absolute immunity that's conferred on judges, on guardian ad litems, should be changed to qualified immunity that's well sufficient for all other government officials. Why should it be different at the family court level? Now, let me also suggest, I believe, that in going forward, we need to have some kind of political strategy. How do we get these issues on the table so you get real traction? One, I think there needs to be an organized effort to get this issue. Your local newspaper, meet with the board of editors. You can have this issue raised at state legislative level with oversight hearings. Those are ways, but you have to be persistent. You know, write and lobby, go in face to face. This is a very serious problem, and show that you care. It should be an issue that you would want to raise in the election campaigns. Are you for this or that statute? You want to make certain that we come in with state legislature with draft legislation that is respectful, is professionally drafted. I do think we probably, my belief is that if you took maybe a half dozen lawyers who are gifted on process, come up with our own uniform family code law that promises it's not going to cure everything because, you know, mankind's made of crooked timber, but at least it would be a huge start. That's what we need to remember. It's never going to be perfect because we're dealing with imperfect human beings, but we can certainly do a lot better than what we're doing now. Family court is it's a tragedy. It's kind of goes back to Star Chamber in Great Britain. You know, it's only about 4 centuries old. But I want to underscore again, the status quo has very vigorous defenders. They're benefiting from this. They are not going to idle. If we aren't, you know, no matter what we do, we have to have the same organization, the same brains, the same persistence, the same maybe skin in the game, because you're not going to win by philanthropy.
Seneca Falls did win by philanthropy. Susan B. Anthony wasn't philanthropy. That doesn't mean we need Elon Musk or George Soros, but it needs people have to care enough about it that they'll have a sustaining effort. The other thing in politics is that, how fast is this going to happen? Nobody knows, because politics is very flukish as to what jumps to the front of the queue and what does not. Things happen every day that can distract legislators. But you need to be committed that you'll stay in it to the very end. I was born in Cambridge, Massachusetts, and early on I was associated with William Garrison, who was a hero in Boston. He, in 1833, established the Liberator magazine. It was viewed the Constitution as a covenant with hell. He was an abolitionist. The first day he established the magazine, he was tarred and feathered and driven out of town. He kept up. He was there in 1865 when the anti-slavery amendment was ratified. He shut down the Liberator after that. But he didn't know it was going to be 32 years. Nobody does. And so if this is going to succeed, everybody needs to be committed. Just ask how long it's going to take, as long as needed. And I repeat again, don't worry. Those who are defending the status quo, they're going to be trying to defend their privileges all the time, 24/7, 365 days a year. So thank you for listening.